suit predated the complaint breach by the Speaker, because it was filed 2 days before the Speaker's complaint conduct.
Yes, on that issue, it's right, because, the court has jurisdiction to entertain actions. Now, what is an action? We all know. Is the allegation and enumeration of those set of facts, which, if proven, will entitle somebody to relief. And those set of facts cannot arise in a vacuum. There must be cause and effect. Otherwise, once it's settled that the Supreme Court does not offer advisory opinions, if you come before the course of action has arisen, you are seeking an advisory opinion, but has no jurisdiction. In any case, a party that launches a premature suit has to be thrown out, simply because he has no suit, valid suit, before the court to adjudicate upon. It's as simple as that. But you cannot mount a premature suit and then later try to feed facts which have arisen to show that now the suit has matured. The suit has been filed already. You deal with it as it is filed and as at the time it is filed. That is how jurisdiction is ascertained, not through subsequent events relating to a matter instituted before a court in order to ascertain course of action.
Gary Nimako here says that he believes that there ought to be an amendment, but the fact that there was no amendment still doesn't change much for him. You don't share that view. In fact, the court, we understand, courts can take judicial notice of things that are, as it were, notorious. And the court took judicial notice of the declaration of vacant seats by the Speaker, even without the plaintiff amending his writ, especially as on the record, the record of the proceedings of that day's sitting was before the court, regardless that we have been told that that was not certified.
Well, that's an evidential matter. Evidential matter arises in the course of hearing a matter you have jurisdiction over, ab initio. Then you can judicially notice notorious facts, but not when the action is non-es. It's non-es. I think, it's too late to contend that a premature suit is a jurisdictional matter, ab initio. And you cannot subsequently plead facts which have happened subsequently to relate back, because it will involve the doctrine of relation back to the time of the institution of the suit. So you cannot use subsequent facts to relate back to an action that was non-est, ab initio, not a matter of amendment.
Still around the jurisdiction issue, is anything wrong with the court, the majority, relying on depositions in the Speaker's affidavit in support of, his application to set aside the stay of execution, which was dismissed? They rely on the affidavit evidence to argue the point of the jurisdictional challenge. when they admitted that the Speaker did not file a statement of case. If the Speaker has not filed a statement of case, and this is already on the record in the court, can they rely on it?
Well, I wouldn't fault them for that, because in the course of adjudication, the court is entitled to take notice of all matters that have been adduced or filed before it. That's one of them. And it's even to the Speaker's interest that they did that, because he didn't file anything, yet they went fairly to what he had put before them already, related to the same issue of jurisdiction anyway, to kind of still give him some hearing. I don't see any problem with that. And let me make this clear. Even if a document is void, null and void, it does not preclude the court from using facts contained in it for any purpose.
Okay. Now, having spoken about how premature this, because it was a, you say it was a non-ex, and could not be cured by how things have happened. Yeah. There is a part of the judgment, there's a statement at page 14 of the lead decision. I want to read it to you again and find out if you don't share the view that it dislodges your preference for the basis on which the minority dissented and dismissed the suit on jurisdiction. They said that this suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H to establish the legal threshold for triggering its provisions, without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation under Article 2(1) and 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court.
This a novel constitutional interpretation and principle. I'm sorry, I cannot agree with that. To all due respect to them. The cardinal question is not the ratum of the matter that to deal with. This jurisdictional matter. Jurisdiction, I mean, as like lack of capacity, it's like an axe. When it falls, it falls. That is it. So it's not a question of good intendment. It's a question of existence or non-existence of the jurisdiction. So you don't want to excise one part of a matter relating to a jurisdiction entrusted to another body and start dealing with it. It is the corpus of the subject matter is about vacation of seats in Parliament. That's the corpus. Afeyo Maken didn't go to the Supreme Court simply because Bagwen was interpreting an article, because it affected the vacation of seats. That was the substance of the matter. So you cannot, I mean, it's an established principle of the courts that however you camouflage your course of action, which properly should belong to another forum, I mean, you'll be be directed to that forum.
You essentially agree with Thaddeus Sore, Kuku Ansan Sare, Kwame Akufu that the judgment is not accompanied by any orders and therefore, like Kwame Akufu puts it, without teeth and grip.
Well, that is as regards its enforceability. Yes, the Constitution itself, says so. Because Article 2 doesn't stop at declaration. It goes further. Say the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. So the Constitution itself is there that the bare declaration to be effective needs further orders. It's quite clear. So if we just stop at a declaration, it has legal force, but the enforceability aspect of it is absent.
Are you saying by this, and this will be my final question to you, are you saying by this that your earlier reference, which we have all heard, to Article 3, Clause 3, on the binding nature of the decision of the court, and you use the same thing to caution the Speaker against disobeying the court, you gave the admonition even before the judgment was released. Does anything change now?
Well, at that time, I think you, the media, spelled out my interview jurisdiction. I asked for the circumstances of the suit, and then the order that the Supreme Court made on the application for stay. And I was saying that, and they even said that the Supreme Court did not only order a stay, they said that the MPs affected should be allowed to continue until the determination.
That's right.
These were the facts put before me. And upon that, certainly if that directive was given, was stuck to the stay order, there was an enforceable decision in which the directive or order which the Speaker should not violate on pain of the sanctions of Article 3. But now, the substantive thing has come. And that interim order has lapsed following the determination of the substantive matter. And the substantive matter stands as a bare declaration. So, it's quite...
All right. Justice Williams Atuguba, thank you.